It is a momentous, major decision, and I want to read to you from what Justice Sotomayor says at the end of her dissent, because I've never seen language like this in a Supreme Court opinion. She says, quote, "Never in the history of our republic has a president had reason to believe he'd be immune from criminal prosecution if he used the trappings of his office to violate the criminal law. Moving forward, however, all former presidents will be cloaked in such immunity. If the occupant of that office misuses official power for personal gain, the criminal law that the rest of us must abide will not provide a backstop." And here's how she ends her dissent, Katie. "With fear for our democracy, I dissent."
I mean, it doesn't get stronger than that, Neil.
Earlier today, after months of delay, the Supreme Court of the United States finally issued a ruling about whether presidents of the United States are entitled to absolute lifetime sovereign immunity, which would effectively make them god kings above the rest of us. And what they decided was, yeah, kinda. It was nearly as disastrous as it could possibly be, and a decisive victory for convicted felon Donald Trump. But before we unpack all that, if you end up liking this video and you want to support the channel, please be sure to hit the like, subscribe, and alert bells before you go. All right, friends, we have several clips to talk about in this video, but here's the long and the short of it. So according to the Supreme Court of the United States, on a 6-3 partisan ruling, under our constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. And he is entitled to at least presumptive immunity from prosecution for all his official acts. There is no immunity for unofficial acts. Okay, we're going to deal with all of that, but the long and short of it is a decisive victory for Donald Trump and effectively puts the president above the law, at least for some acts. And by some, we mean a lot. What do official acts mean? What do unofficial acts mean? It's hard to tell, but before we get into all of that, I just want to remind you, the conservative justices who've given this power, this absolute sovereign, despicable relic from monarchies in the past, to our president, our chief executive, remember, they're supposed to be originalists. They're supposed to actually look to the language of the Constitution. What did the founders want? Well, as one MSNBC analyst puts it, that's ridiculous.
It sounds like they're creating a special category for Donald Trump, a special category that hasn't existed. A carve-out for him. A carve-out that if you look at the historical record, Sotomayor argues, never existed until today. And I'll read a little bit more from her dissent because she, we always hear about conservatives citing the Federalist Papers and citing historical context, and this is an originalist court. They're going to take an originalist view of things. Well, she cites the Federalist Papers for her purpose. She says the historical evidence that exists on presidential immunity from criminal prosecution cuts decisively against it. For instance, Alexander Hamilton wrote that former presidents would be, quote, liable to prosecution and punishment in the ordinary course of law. That's Federalist Paper number 69, page 452, if you have one of them at home. For Hamilton, that was an important distinction between the King of Great Britain, who is sacred and inviolable, and the President of the United States, who would be amenable to personal punishment and disgrace. I mean, if you're going to say that you believe in historical precedent, how much clearer does it get than Alexander Hamilton saying liable to prosecution and punishment in the ordinary course of law? We fought a revolutionary war.
Again, it's because originalism and originalists, they cherry pick, right? This idea that they're principled and they're consistent. Number one, they're not historians. And number two, given the body of jurisprudence, given the facts in this history, you can cherry pick whatever you want. For their argument, they're like, listen, the framers wanted a vigorous and active and energetic executive. So you don't want them worrying about, like, my God, can I be prosecuted if I break the law? That might take the energy. That might make them take them from high energy to Jeb Bush low energy. And we can't have that. Even though the founders explicitly stated, we don't want our chief executive to be monarchs. Monarchs are sovereign. King Charles of Great Britain is sovereign. He is above the law, but that's a monarch. And the president is not supposed to be a monarch. So again, as she points out, they cherry pick. They're hypocrites, and that's why you should take none of their analysis seriously. Now, getting back to, well, hey, listen, Josiah, hey, at least they say unofficial acts are not immune. So listen, sure, maybe presidents are above the law most of the time, but sometimes they're not, right? Unofficial acts, they can be prosecuted. Well, they kind of stick the shiv in here. From the majority opinion, in dividing official from unofficial conduct, courts may not inquire into the president's motives. It's Such an inquiry would risk exposing even the most obvious instances of official conduct to judicial examination on the mere allegation of improper purpose, thereby intruding on the Article 2 interests that the immunity seeks to protect. Interesting stuff. I mean, just so ridiculous. So, for example, you want to talk about protection from, what counts as an official act? Well, so for example, when Donald Trump tried to work with his Justice Department to pressure state legislatures and state officials into taking actions that would give him victory in the 2020 election and threatening to fire Justice Department officials if they refused to comply. Well, he's entitled to absolute immunity. The president can't be prosecuted for conduct within his exclusive constitutional authority. Trump is therefore absolutely immune from prosecution for the alleged conduct involving his discussion with Justice Department officials, because he's their boss and he can fire them whenever he wants. So even if he's doing so corruptly, I mean, it's an official duty. You can't examine it. He's entitled to absolute immunity. What about the vice president? The vice president. Well, they say, listen, for the vice president, he's entitled to presumptive immunity, right? Because the vice president and the president, like, they correspond. That's an official duty. But you know what? The vice president is also nominally the head of the Senate, so maybe there's something there. But even in this respect, he's entitled to the presumption. You have to just assume that he's absolutely immune. And if you want to challenge it, then you got to take it to court. So again, they impose a ridiculously high standard over Trump. And actually, as a matter of fact, before I show you some of the other things, I want to just bring this to your attention as well, just to put it in perspective in terms of the hurdles they throw in the way.
She's saying the court's creating new rules of evidence that bar what everybody would say is relevant and the jury should know about it. Now a jury isn't even going to be allowed to know about things like Trump's communications with the Justice Department because that's an official act.
There's an emphasis within the majority opinion of how context is important for the consideration of what constitutes an official or unofficial act. And yet, how can you have context if you can't consider motive? How can you have context if you can't consider these, quote, official acts in the whole kind of scheme of what happened? And I think that's particularly problematic.
Exactly, right? They create this ridiculously high standard and then effectively kneecap it. And then the best part about the majority opinion before I get to the dissents, the majority chides the dissents. They strike a tone of chilling doom that's wholly disproportionate to what the court decides today. Don't freak out, guys. Just trust that when we make the most powerful person on earth even more powerful, much more powerful, because we are removing them from the potential of prosecution in the event that they break the law, you can just listen, don't worry about it. We need a vigorous and energetic executive. And hey, it's still possible that if you jump through all of these hoops, some of what they do may be criminally prosecutable. Ridiculous. Let's get to the dissents. So Justice Sotomayor, with whom Justice Kagan and Justice Jackson dissent, again, the three liberal justices, makes a mockery of the principle foundational to our constitutional and system of government that no man is above the law, because our Constitution does not shield a former president from answering for criminal and treasonous acts. I dissent. We're going to scroll through some of this, the best moments. The majority makes three moves that in effect completely insulate presidents from criminal liability. First, the majority creates absolute immunity for the president's exercise of core constitutional powers. This holding is unnecessary to the facts of the indictment, and the majority's attempts to apply it to the facts expands the concept of core powers beyond any recognizable bounds. Second move, which is to create an expansive immunity for all official acts, whether they're described as presumptive or absolute. Under the majority's rule, a president's use of any official power for any purpose, even the most corrupt, is immune from prosecution. Finally, the majority declares that evidence concerning acts for which the president is immune can play no role in any criminal prosecution against him. That holding, which will prevent the government from using a president's official acts to prove knowledge or intent in prosecuting private offenses, is nonsensical. You see? Again, a good example here. Is there any way to read the majority such that ordering the military to assassinate a domestic political rival isn't an official act and therefore is absolutely immune? Elie Mystal, progressive commentator and lawyer, says this. Think about it this way. How would you prove assassination was unofficial? Evidence of what the president said to his advisors cannot be used against them, apparently. So if a president says it's official, how do you rebut the presumption? Exactly. They effectively have given license to the president to do the absurd things in the hypotheticals that we have discussed over time. Folks, this is absolutely, absolutely disgusting. Couple of other things to point out here. We talked about that. The main takeaway of today's decision is that all of a president's official acts defined without regard to motive or intent are entitled to immunity that is, quote, at least presumptive and quite possibly absolute. So even the presumptive part, that's just a bare threshold. It may actually be absolute as well. She points out as well in her dissent that the framers knew how to provide for immunity from prosecution because they did for members of Congress, narrow immunity for members of Congress in the speech or debate clause, but they didn't include one for the president. They also understood that state constitutions at the time provided criminal immunities to sitting governors, the chief executives of states. So they were aware that basically the little mini presidents of, the various states at the time had, some of them, criminal immunities, but they didn't make one for the president of the United States. They chose not to use similar language. And again, we talked about, we showed in that clip how the founding fathers were clearly opposed to giving the chief executive this sort of broad immunity. They wanted a powerful chief executive, but a constrained chief executive, not just with checks and balances, but also criminal liability. And she goes into the detail and cites that some, not all, some of the founding fathers to that effect. There's plenty more evidence. This historical evidence reinforces that from the very beginning, the presumption in this nation has always been that no man is free to flout the criminal law. This majority purports to keep us in suspense as to whether this immunity is absolute or presumptive, but it quickly gives up the game. It explains that at a minimum, the president must be immune from prosecution for an official act unless the government can show that applying a criminal prohibition to the act would pose no dangers of intrusion on the authority and functions of the executive branch. So think about it. Presumptive immunity is a de facto absolute immunity because the government has to prove, hey, listen, we want to override this presumptive immunity, but there's no threat, none, to executive power in so doing. Justice Sotomayor says that's mutually exclusive. You can't do it. By its very definition, there's no way to protect against potential intrusions. She says, it's hard to imagine a criminal prosecution for a president's official acts that would pose no dangers of intrusion on presidential authority in the majority's eyes. Nor should that be the standard. Surely some intrusions on the executive may be justified by an overriding need to promote objectives within the constitutional authority of Congress. And she cites Nixon versus the Administrator of General Services, a case from 1977. Right? Do you see where they have created an impossible standard? And that's not even factoring in the fact that you can't consider motive. Folks, this is just absolutely dangerous. Another example I just want to point out here. For instance, the majority struggles with classifying whether a president's speech is in his capacity as president, official act, or as a candidate, unofficial act. Imagine a president states in an official speech that he intends to stop a political rival from passing legislation that he opposes, no matter what it takes to do so, official act. He then hires a private hitman to murder that political rival, unofficial act. Under the majority's rule, the murder's indictment could include no allegation of the president's public admission of premeditated intent to support the mens rea of murder. It's a strange result, to say the least. Folks, this is where we are. I don't know what to say about this. Like I said, I suppose it's not the absolute worst case scenario, but it's like a hair's breadth away from it. It is about as disastrous as it could possibly be. As somebody who supports the current president, Joseph Robinette Biden, and Democratic presidents in general, I just want to say for the record, I don't think any president, any Democrat or Republican, should be entitled to absolute lifetime immunity. It's gross, it's un-American, it's incredibly dangerous because that position is already powerful enough. And we've had no frivolous indictments of presidents. This idea that, oh my God, if you put presidents, if you force them to comply with law, it opens the floodgates. We have laws protecting against frivolous lawsuits. The criminal burden still has to be met. You still have to indict, you have to impanel a grand jury, you have to have the investigation, you have to make the case in court, you have to make the case beyond all reasonable doubt in front of a jury of its peers. And yes, if I have to choose between every president being concerned that what they do may or may not violate the law and take that into consideration before they act, versus presidents, Democrat or Republican, who feel that they're given a blank check to do whatever they want with impunity. Yes, I'd much rather have a fearful president, a president concerned about the legality of actions, than an uninhibited one. And I don't know why that's at all a close concept. But that's where we are. This is incredibly dangerous. Again, a decisive victory for Donald Trump. And the real question is, what are Democrats going to do about it in response? Let me know what you think in the comments.